Hello, I'm Katie Broomfield, a researcher in the Department of History at Royal Holloway, University of London. Following a military coup in September 1973, Augusto Pinochet installed himself as the head of state of Chile. He was president of Chile from 1973 until 1990 and retained military command in the country until 1998. During this period, innumerable crimes against humanity, including torture, hostage-taking and murder, took place in Chile, for which Pinochet was said to be responsible. Among his most vocal critics was Amnesty International, a charity which exists to protect and promote civil liberties and human rights. In October 1998, while he was on a visit to London, the Spanish authorities issued international warrants for Pinochet's arrest, to enable his extradition to Spain to face trial for crimes against humanity. He was arrested on the 10th of October 1998 and immediately applied to the High Court to quash the warrants on the basis that he was entitled to immunity from arrest as a past head of state. Amnesty International applied and were given permission to join the proceedings as an interested party. In the High Court, the warrants were quashed and an appeal was lodged with the House of Lords as to the extent of the immunity that could be afforded to a former head of state. An order was made on the 25th of November 1998 by a majority of 3-2 that Pinochet was not immune from prosecution. It later emerged that Lord Hoffmann, who agreed with the majority, was a director and chairperson of Amnesty International Charity Limited. As a result, Pinochet applied to have the order of the 25th of November set aside, arguing that the opinion of Lord Hoffmann should be declared to be of no effect. I'm now joined by Dr. David Yuratich, a lecturer in law at Royal Holloway, University of London, to find out more about what happened in this case. David, firstly, I wanted to ask you, if the House of Lords, what is now the Supreme Court, is a final court of appeal, how did Pinochet manage to bring these proceedings?
Of course. So Lord Brown-Wilkinson explained this in his judgment. So he said that although, yes, you're right, that the House of Lords, as it then was the ultimate court of appeal, it did, however, have the power to correct any injustice caused by an earlier order. But he did also say that this isn't an automatic right. He said that it would only reopen an appeal in circumstances where, through no fault of a party, he or she has been subjected to an unfair procedure.
And what was the court being asked to decide in this case?
So remember, we're talking here about two separate cases. Pinochet number 1, which is the one that Lord Hoffmann sat on, that was about whether Pinochet was immune from prosecution as a former head of state. This case, Pinochet number 2, is asking whether Lord Hoffmann's judgment, and therefore the entire decision in Pinochet number 1, should be set aside on the basis of Lord Hoffmann's links with Amnesty International.
What exactly was Lord Hoffmann's relationship with Amnesty International?
Well, Amnesty International is quite a well-known international organisation whose headquarters are in London, and Amnesty campaigns on human rights issues worldwide, so it's quite associated with things like abolition of the death penalty and torture of political prisoners and things like that. Now, Lord Hoffmann was a director and chairperson of Amnesty International Charity Limited, which was established to undertake aspects of Amnesty's work which counted as charitable under UK law.
So why would that disqualify him from sitting in the first Pinochet case?
There's a principle within the common law that goes back a very long time based on the idea of natural justice, and it's a principle that's based on the idea that a tribunal shouldn't be biased, decision makers should not be biased. And we often say that they should not have a judge, you should not be a judge in your own cause. In other words, you shouldn't have a vested interest in the outcome of the litigation. So a good example of this is the case of Dimes and the proprietors of the Grand Junction Canal. That case, the then Lord Chancellor was sitting as a judge, and Unknown to the Lord Chancellor, who appeared to have just forgotten or not realised, and unknown to the parties, the Lord Chancellor had substantial shareholdings in one of those two companies. And so it was found that given his financial interest in that case, he should not have sat, and so the order of that case was set aside.
Did Lord Hoffmann have a financial interest in Amnesty International?
No, he didn't, and so it's quite important here to think about what's going on here. Quite often it's obvious when there is a financial interest that it's going to be an unfair tribunal, that you will be a judge in your own cause. But that's not the case here, and it's quite strange. Amnesty's interest in this litigation was to see that Pinochet was first shown to not be immune from prosecution, and then of course they wished to see him put on trial, and of course Amnesty felt that he was guilty and wanted him to be found guilty at trial. That was their interest, not a financial one. And so it's sometimes a bit odd to see those kind of non-financial interests appearing in criminal cases in particular. Lord Hope explained that the maxim that no person may be a judge in his own cause usually arises in civil litigation, and it's only in the most unusual circumstances that a judge who was sitting in criminal proceedings would find himself open to the objection that he was acting as a judge in his own cause. And he said that this case was one that you could perhaps better describe by talking about the notion of impartiality, the fact that justice must not only be done, it must be seen to have been done.
And where does that principle come from?
Well, that's with the idea that no man may be a judge in their own cause. It's got a very long lineage, but that particular formulation of it comes from a 1924 case, the Crown and the Sussex Justices ex parte McCarthy. In that case, Lord Hewitt said that a long line of cases, even in 1924 it's a long line of cases, shows that it is not merely of some importance, but it is of fundamental importance that justice should not only be done, but should manifestly and undoubtedly be seen to have been done. So the question was whether Lord Hoffmann's links with Amnesty International and Amnesty's non-financial interest in the outcome of this case was sufficient to automatically disqualify Lord Hoffmann on the basis that a person may not be a judge in his own cause.
Was Pinochet's objection to Lord Hoffmann that he was biased?
No, it wasn't. So Pinochet, and nobody in fact who was a party to this case, said Lord Hoffmann was directly biased against Pinochet. That wasn't what it said. The argument was that given the Lord Hoffmann's role at Amnesty International Charity Limited, the very close relationship between charity and Amnesty itself, and Amnesty's, as I mentioned, non-financial interest in the outcome, whether that was sufficient to show that there was the appearance of possible bias in this case. So it comes back to justice has to be seen to be done. And so that was the question, because the House of Lords did accept that if Lord Hoffmann had been a member of Amnesty International itself, he would definitely have been disqualified.
Did it make a difference that Lord Hoffmann was a director of Amnesty International Charity Limited rather than Amnesty International itself?
Well, no, it didn't make a difference the way it works out in the wash, if you like. So Lord Brown-Wilkinson said, when it comes to judicial impartiality, there is no room for fine distinctions. And so, although technically these were separate entities, the relationship between Amnesty International Charity Limited and Amnesty International was so close that in practice it appeared as if Lord Hoffmann was in fact being a judge in his own cause.
And is that what was decided in this case?
Yes, that's right. So the Law Lords agreed unanimously that Lord Hoffmann should have been disqualified from sitting in Pinochet number 1. And they quoted from Dimes that the maxim that no man is to be a judge in his own cause should be held sacred, and that is not to be confined to a cause in which he is a party, but applies to a cause in which he has an interest. And Lord Brown-Wilkinson just clarified, the rationale of the whole rule is that a man cannot be a judge in his own cause, A judge is automatically disqualified if he stands to make a financial gain as a result of his own decision in the case, and the rationale applies just as much in a situation where a judge may have a non-financial gain from the case. The Pinochet case attracted much public and press attention. It was reported in the Times that it put the elite group of 12 men who constitute the highest court in the land under public scrutiny for the first time, making them what one senior judge called a laughingstock, with Lord Hoffmann being criticised for failing to declare his links to Amnesty International at the outset. There was absolutely no suggestion by anyone involved in the case that Lord Hoffmann was actually biased against Pinochet. As Lord Hutton said, however, public confidence in the integrity of the administration of justice would be shaken if this decision were allowed to stand. The Law Lords held that he was automatically disqualified from hearing the appeal as a matter of law by reason of his directorship of Amnesty International Charity Limited, a company controlled by a party to the case, Amnesty International. As a result, the order of 25th of November was set aside and a rehearing was ordered before a differently constituted panel of 7 law lords. They decided by 6-1 that Pinochet was not immune from prosecution. His extradition was subsequently blocked by the Home Secretary on the ground of Pinochet's ill health. Pinochet returned to Chile in March 2000, and in 2004 a Chilean court ruled that he was medically fit to stand trial and he was placed under house arrest. He died 2 years later, on 10th December 2006, with hundreds of criminal charges still pending against him. Not long after this decision, the Human Rights Act 1998, which enshrines the European Convention on Human Rights in UK law, came into force. Article 6 of the Convention guarantees that, in the determination of his civil rights and obligations or of any criminal charge against him, everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. In the words of Lord Hope, one of the cornerstones of our legal system is the impartiality of the tribunals by which justice is administered.